Hello, and welcome to a special presentation of a debate among the candidates seeking seats on the Montana Supreme Court. We're coming to you live from the Castle Center at the University of Montana School of Law in Missoula, where all 5 candidates are here to present an overview of their perspectives, answer questions from a panel of moderators, and perhaps take a few questions or comments from the audience in attendance here at the Castle Center. Our MC this evening is Laura Walker, a first-year law student here at the law school and vice president of the Federalist Society, one of several organizations sponsoring tonight's events. Laura?
Good evening, everyone. My name is Laura Walker, and I'm the vice president of the Federalist Society. And it is my pleasure tonight to welcome you to the Montana Supreme Court candidate debate. At this time, I would like to remind everyone to turn off their cell phones and pagers. Thank you. This debate tonight was brought about by the collaborated efforts of many groups, and they really deserve our thanks, from the Federalist Society, the American Constitutional Society, the College Republicans, Environmental Law Group, Montana Trial Lawyers Association, the New Lawyers Section of the Montana State Bar, the Women's Law Caucus, Stacy Gordon, Robert Nadelson, Dean Fritz Snyder, Dean Tonin, and all the library and law school faculty and staff. All the groups involved have been truly dedicated and worked hard to make this debate happen. Thank you very much for all of your time, work, and sponsorship. Your efforts are truly appreciated, and you do deserve a round of applause. After introductions tonight, the candidates will be asked questions developed by our moderators. Each candidate will be asked a specific question. They will have 2 minutes to respond, and then all the remaining candidates will have 1 minute to respond to that response. Then we will be taking questions that have been submitted by the audience. We have great moderators tonight, and I would like to introduce them. Greg Monroe, a professor and practical skills director here at the university and a member of the Montana Trial Lawyers Association. Karen Townsend, the chief deputy attorney from the Missoula County Attorney's Office. Karen Juris, a professor here at Kristen Juris, a professor here at the University of Montana School of Law, and Shandor Badarudin with the law firm of Madarudi, Gooch, and Badarudin. Our moderators tonight have worked hard and have generally devoted their time and effort to develop questions to get to the issues that will be facing our Montana Supreme Court in the upcoming years. And I would like to thank them now for all their time and dedication. Now, ladies and gentlemen, I would like to introduce you to the Montana Supreme Court candidates. Jim Nelson has served as Justice of the Montana Supreme Court since his appointment by Governor Roscoe in May 1993. He is the second senior justice on the court, having sat on 3,000 direct appeals and 7,000 cases. Prior to that, Jim engaged in the general practice of law in Cut Bank for nearly 20 years, representing individuals, small businesses, ranchers, and farmers in domestic relations, real estate, litigation, contracts, wills, probate, estate, and oil and gas matters. Jim served on the board of First International Bank. He was president of the Cut Bank Chamber of Commerce and was a volunteer fireman. He also served as the Glacier County Attorney for 14 years. Jim obtained his bachelor's degree in business from the University of Idaho in 1966 and his law degree from George Washington University in 1974, where he attended law school at night while working full-time for the Securities and Exchange Commission. He served as a member and as chairman of the State Board of Oil and Gas Conservation and as a member of the State Gaming Advisory Council. He's also a member of the Governor's Advisory Council on Corrections and Criminal Justice Policy. Jim presently serves as the Supreme Court's liaison to the Commission of Courts of Limited Jurisdiction, as a member of the State Bar of Montana CLE Institute, and as a member of the State Bar of Montana Judicial Regulations Committee. He's a member of the State Information Technology Board and serves as chairperson of the Supreme Court's Commission on Technology. He also serves as one of Montana's commissioners to the National Conference of Commissioners on Uniform State Laws. During the spring semester 2001, Jim taught Criminal Law and Procedure 2 as an adjunct professor at the University of Montana School of Law. Jim is a veteran, having served as an officer in the United States Army. He and his wife, Carrie, have been married 34 years and have 2 grown children and 3 grandchildren. Ladies and gentlemen, Jim Nelson. You can address the crowd now.
Oh, thank you, Laura. I thought you were going to introduce everybody all at the same time. This is an extremely important race for the court, and as Laura has indicated to you in the background information that she just read, I bring 30 years of experience, public service, and accomplishment to the court. I think it's extremely important that we retain this kind of experience on the Montana Supreme Court. Our court is facing every year increase in caseloads and some of the most important issues that Montanans have dealt with in decades. These races are nonpartisan races, and I think that's extremely important. And they're nonpartisan races for a very good reason. There aren't Republican rights and Democrat rights. There aren't Republican laws and Democrat laws. There are simply constitutional rights and laws of this state that we all share and must obey and deal with as citizens of this state, and with respect to federal constitutional rights as citizens of this country. So it's very important that these races be nonpartisan and remain nonpartisan. I can't overemphasize the importance of these Supreme Court races. What we're dealing with is whether or not the commitment that our Supreme Court has demonstrated to supporting and defending and protecting Montanans' unique constitutional rights under our 1972 Constitution will go forward, or I think will lapse. And that's why I think that this race is so important. That's why I suggest to you that it's important to keep judges on this court and elect candidates to this court who are committed to supporting, protecting, and defending the Constitution, because in the final analysis, that is absolutely the only promise that any judicial candidate can make to you.
Thank you, Justice Nelson. Cindy Yonkin. Cindy Yonkin. Cindy Yonkin grew up in Whitehall in Manhattan, Montana, where she graduated from high school in 1976. She graduated from Montana State University Bozeman with a bachelor's in microbiology in 1982. During college, Cindy traveled the world with the international youth group Up With People. After graduation, she served with the United States Peace Corps for 2 years in the Fiji Islands. Cindy graduated from law school at Lewis and Clark College in Portland, Oregon in 1989. She worked as a summer student clerk for then Chief Justice Turnage in 1988 and spent her third year of law school at the University of Montana School of Law. In 1989, Cindy began practicing law with Moore, O'Connell, and Reffling in Bozeman, where she is currently a partner. Her practice focuses primarily on water rights, real estate transactions, property, and estates. Cindy currently serves as city attorney for White Sulphur Springs. In 1995, Governor Mark Roscoe appointed Cindy to chair the Montana Board of Environmental Review. In 1998, Cindy was first elected to the Montana House of Representatives, where she has served 3 terms. For the past 2 sessions, Cindy has been the chair of the House National Resources Committee and the House Majority Whip. Cindy also serves on the board of the Vigilante Theater Company, Five Rivers chapter of the American Red Cross, and the Gallatin 4-H Foundation. She has served the American Legion Auxiliary Girls State Program, the United Way, and is currently the president of the Gallatin Empire Lions Club, where she has been honored as a Melvin Jones Fellow. Cindy has been married to her husband, Terry Corll, for 14 years. Ladies and gentlemen, Cindy Yonkin.
Thank you very much, and I'd like to thank all of you for coming and having interest in this very important race, and thank you to all of the moderators and the organizers. I became interested in running for the Supreme Court after my legislative service and my law practice both. In both of those areas, and in particular in my legislative service, I have routinely focused on what is the proper role of the respective branches of government. And I believe that the Montana Supreme Court has, in the last decade, gotten a bit far afield from what their constitutional mandate is, and that is interpreting and applying the law. I believe very strongly that the appropriate place for public policy to be made is with the legislative branch of government, which is closest to the people, and where the people have the greatest opportunity for input into the public policy making process. When the court system gets into public policy making, the public is left out of that. And I don't think that that's fair to the public, and it's not fair to the people that are in the business of making public policy. The electorate sends their representatives and senators to the legislature, and there is ample opportunity for their input. When the court system does public policy or directs and makes public policy, the public is left out of that. You all know that you don't get to lobby judges, and there's a very good reason for that, because when you do lobby judges, then the litigants are the ones that are left out of that process, and their ability to have a fair and impartial trier of fact and fair impartial application of the law is severely compromised when judges and courts consider and try to direct the public policy. So it was for that reason that I decided to get into this race, and I think that it is critically important for Montana to have a court that sticks to the business of interpreting and applying the law and following the law that was intended by the people of Montana through their elected legislature, or directly by the people of Montana in their constitution, or by voter-passed ballot initiatives and referendums.
Thank you, Mrs. Yonkin.
Thank you.
John Warner. Justice Warner was born on January 22, 1943 in Great Falls, Montana. He graduated from high school in Great Falls, and he earned his bachelor's degree in history and political science from the University of Montana in 1965, and graduated from the University of Montana School of Law in 1967. Justice Warner was a law clerk for the Montana Supreme Court from 1967 to 1968, and then he practiced law in Havre, Montana for 20 years, specializing in litigation. He served as chairman of the Supreme Court Commission on Uniform District Court Rules and was both a trustee and president of the State Bar of Montana, as well as the Havre City Attorney. In 1988, he was elected District Judge of Montana, 12th Judicial District. He was re-elected in 1994 and 2000. While on the trial bench, Justice Warner was president of the Montana Judges Association, chairman of the Senate Review Division of the Supreme Court, served on the District Court Council, and was chairman of the Montana Judicial Standards Commission. He was appointed a justice of the Supreme Court in May of 2003. He currently serves on the teaching staff of the Commission on Courts of Limited Jurisdiction, the Supreme Court Commission to review the canons of judicial ethics, and the State Bar of Montana Judicial Relations Committee. Justice Warner and his wife Catherine have 6 grown children and 12 grandchildren. Ladies and gentlemen, Mr. Warner.
Naturally, I too thank all of you for coming and showing your interest tonight. I've had a career in the court system that I've dearly loved since 1967. I can honestly say that the seat that I hold at this time was not an ambition of mine. It was not a goal. I started out practicing law, and then I became a district judge after a varied law practice for 20 years. Then after 15 years on the bench, in which I actually, as I'm sure you all know that are familiar with the law, seeing just about everything in human existence that goes on, from civil litigation to the high-profile cases that we talk about here, to the dependent neglected actions, to the domestic relations cases, everything from zoning ordinances, and a very, very substantial criminal caseload that is growing all of the time on the business end of that caseload. I finally decided, when the vacancy became open, that perhaps I had something to give to the Montana Supreme Court. I do come, and I did come, and I am on the Montana Supreme Court with no agenda whatever. I believe that it is my obligation to be, and I will strive to be, a fair and impartial jurist, one that will apply the law as given to me. I believe that I have gained a substantial amount of knowledge and experience over the years, And perhaps my experience on the trial bench will bring a dimension to the court. And I think, although the other justices are not here, that maybe I have had an effect. And under these circumstances, I'd like to continue serving. I would not be called a judicial activist. On the other hand, I know that when the decisions have to be made, I can make the tough calls. And I will read the law and try and apply it to the best I can.
Thank you,
Now
Mr.
there's,
Warren.
oh, okay.
Brian Morris. Brian Morris was born and raised in Butte, Montana, and graduated from Butte Central High School in 1982 as valedictorian. He attended Stanford University on a football scholarship and played varsity football from 1982 to 1986 and graduated from Stanford with a bachelor's in economics in 1986 and his master's in 1987. He graduated with distinction from Stanford Law School in 1992. During school, he served as associate editor of the Stanford Law Review from 1990 to 1992. He was a law clerk for Honorable John T. Noonan, Jr. at the United States Court of Appeals in the Ninth Circuit from 1992 to 1993, then a law clerk for Honorable William H. Rehnquist, Chief Justice of the United States Supreme Court from 1993 to 1994. He represented interests of American citizens and businesses whose property had been seized following the Islamic Revolution as legal assistant at the Iran-U.S. Claims Tribunal at The Hague in 1994 to 1995, then began private practice in Bozeman, Montana from 1995 to 1999. He represented interests of persons and businesses injured as a result of Iraq's 1990 invasion of Kuwait as senior legal officer at the United Nations Compensation Commission in Geneva, Switzerland from 2000 to 2001. Then he was state solicitor for the Montana Department of Justice in 2001 through the current present day. During that time, he has successfully represented the people of Montana in numerous complex lawsuits. He is the author of several law review and professional journal articles, including Free Speech in Judicial Elections in the Montana Lawyer, for which he received the Haswell Award for Outstanding Articles submitted by a Montana lawyer. He served on the faculty of Appellate Advocacy Seminar for the National District Attorneys Association in 2002, and presented on constitutional law issues and continued legal education seminars in Montana. He married Cherise Prezo, a native of Whitefish, Montana, and has 3 sons, Williams, Max, and Aiden. Ladies and gentlemen, Brian Morris.
Thank you very much. Thank you for having me here this evening. As mentioned, I went from Butte to Stanford University on a football scholarship, and I was a fullback at Stanford. And one of the quarterbacks while I was there was a fellow named John Elway, and John went on to a pretty successful career in the NFL after Stanford. And after Stanford, I went on to law school. But I like to think that, John, I'm just peaking late in life, and our career paths will cross again someday. After law school, I had the privilege of clerking at the Ninth Circuit Court of Appeals and for Chief Justice William Rehnquist, where I had a chance to see up close and personal how an appellate court should operate. And that began my experience with appellate law. Appellate law is all about research and writing. The life of a Supreme Court justice is doing research and writing and being able to persuade colleagues through your written opinions and through the conference. And I've had experience in private practice and as a solicitor here for the last several years, where I've worked on a number of cases that are right at the intersection of law and public policy, including my defense of the state of Montana and the lawsuit filed by the school districts alleging inadequate funding for our school system, and I'm scheduled to defend the class action lawsuit against the state alleging inadequate funding of our public defender system. So the court hears a number of cases that are at this intersection of law and public policy, and is going to continue to do so the next several years, including what's the clean health environment provision mean, what does the right to privacy mean, what about the open government provision. Those are the real important, interesting cases the court hears, but they're a very small fraction of the court's work. The rest of the court cases deal with disputes between real people and real parties, and one of the challenges facing our court is a real crushing workload. And I'm in the prime of my career, and I'm committed to improving the efficiency of our case processing system, making sure people aren't waiting 3 months, 6 months, a year and a half to get cases resolved. And my appellate experience will assist me in those kind of cases to improve the efficiency of the court, but also to deal with those very difficult cases that are at the intersection of law and public policy, and are going to help determine what kind of society we're going to have in Montana for the next 30 years. Thank you.
Ed McLean. Ed was born and raised in Anaconda, coming to Missoula to go to school in 1965. Ed graduated from the University of Montana with a degree in business administration with a major in accounting in 1969. He obtained his law degree from the University of Montana in 1973. Ed had a private practice and was a part-time county attorney until 1975, when the state of Montana went to full-time prosecutors in first-class counties. In 1975, Ed became a full-time prosecutor, working as the chief criminal deputy until 1988, when he was appointed to the district court judgeship. Ed has been a district judge for the last 15 years, and during that time has been chairman of the Judicial Standards Commission, chairman of the Montana Criminal Jury Instruction Commission, past president of the Montana Judges Association, member of the District Court Council, and a member of the State and Federal Regulations Committee for the courts. Ed has completed several of the courses offered by the National Judicial College. Ed has been an active supporter of the Missoula community and the University of Montana for the past several years. Ed's judicial philosophy is one of restraint rather than activism. He believes in the three branches of government and the independent function of each. The legislature is where the public laws are to be enacted. Public discourse takes place in legislative hearings, not in the conference rooms of the Montana Supreme Court. Ladies and gentlemen, Ed McLean.
Again, folks, thank you very much for having us here. You know, when I grew up as a young man in Anaconda, things were tough, and some of us were fortunate enough to be able to go on to school and obtain a higher education. Some of us were not. The big difference was in going to school that some of us were able to put together a few pennies during the summer and some were not. The one thing I learned during the course of life is that because of the opportunity to obtain a higher education, you learn that it makes you much more fortunate and that you're able to practice a vocation that you truly love. And that's how it is with the practice of law and sitting as a district judge. However, it does not make me any more intelligent than my cousins, relatives, or friends that I left behind in Anaconda. What it does teach you is the respect for others in their respective professions, whether it be a police officer, a fireman, a doctor, or a homemaker. What you do is you respect people in their different areas of vocation, and because you're fortunate enough to sit as a judge or a justice, it does not make you more intelligent than any of the rest of those people, nor does it entitle you to the right to second guess them. Your job as an appellate judge is to make certain that the Constitution is upheld and that the laws are applied equally and fairly to all. What you need is a district court perspective who has seen life in the trenches that will apply it equally to all the people before it. And I think I'm the candidate to do that. Thank you.
I just want to let our radio audience know that they are listening to a live broadcast of a debate among the 5 candidates seeking seats on the Montana Supreme Court. We're coming to you live from the Castle Center at the University of Montana School of Law, and we have just heard opening remarks from each of the candidates. Assembled here are a panel of 4 moderators who have prepared questions for tonight's forum. Here again is Laura Walker to get us into that portion of this debate.
At this time, we will open the floor to questions from our moderators. Mr. Butterudin, you may begin.
Thank you. My name is Shandor Butterudin. Mr. Justice Warner, this question is for you. GOP versus White is a United States Supreme Court decision that held that it was permissible for candidates for judicial office to disclose their opinions on a variety of issues that the voters may find important. Do you think that decision was a good decision or a bad decision? And are you prepared to state your opinion on gay marriage, religious displays at government buildings, and tort reform legislation?
The first response that I might make to that is that Judge McLean here is a sitting district judge, and you have 2 justices of the Supreme Court here, so someone could be held in contempt and affirmed right on the spot here tonight. I will try, sir, to answer the questions. And as you can see, that throughout my history on the bench, sometimes a little humor does not hurt. But I want all of you to realize that this is extremely serious, and this is a very serious question, and I do take it very seriously. First question was, do I believe that Minnesota Republicans versus White was a good decision? Good is a generic word. The answer in a word, is, since I'm a plain-spoken person, is no. I do not think it was a good decision. I think it was a decision that was made inadvisedly, that the independence and the ability for the public to have a fair and impartial judicial system, and not only that, the appearance of impartiality is very important. I believe that has been harmed by Minnesota versus White. All right, that's a short answer. We could go on with that for a long time, but I don't have a long time. So the answer, no fish in here, no. All right. The second part is, will I express my opinions? Well, I've stated to the Mr. Inez, I believe he's the Associated Press, that I will do the best I can. I believe that Associated Press versus White, while a bad decision, now you notice I just used the word bad because I don't think it's good, it's the law of the land. And you are a product of where you come from. Sitting on this panel, I've had two hotly contested, very difficult judicial races. The first was to be elected as a district judge, and the second was a retention election in which I had an opponent. And I was asked many of these questions, and I did say that I'm sorry, I cannot do anything other than say that I will be a fair and impartial jurist, which I say now. So I have said that I will do my best, if I can do so without committing myself, without violating the pledge rule, and without forcing myself to recuse myself from all cases that might be called into question because I've expressed an opinion. And then I've been on two panels before with these same slate of candidates, and we're all about saying the same thing, only some of us are saying yes and some of us are saying no. I will say yes, that I will do the best I can. And therefore I will go there. But I have now, and not only now, but before I said this, I did read...
Justice Warner. In the interest of time, we'd like to move on to the other candidates.
Long questions. Okay. And I could give you an explanation, but it's only fair. Who's next?
Nelson.
I think it's a very important question, a very timely topic. We spent a lot of times in past debates on this question. Whether or not it's a good decision, I think, is irrelevant. In fact, it is the law of the land, and it's important to understand that the decision simply precludes state bar associations or states from limiting the ability of judicial candidates to express their personal views. It does not compel anybody to do that. I have taken the position in this campaign, and will continue to take the position, that I'm not going to express my personal views on issues that are either pending before the court or that may come before the court, and there's two reasons for doing that. First of all, the argument goes, well, I'll express my view today to this group of people, but then when it comes time to actually make a decision, all of that goes out the window. I won't use my personal views, I'll just rule on the basis of the case. So I guess that begs the question, if you believe that, why is the candidate's personal views relevant in the first instance? And I submit it's not. Secondly, as Justice Warner indicated, there is the matter of recusal, and we just saw this happen to Justice Scalia, who expressed his opinion in connection with the Pledge of Allegiance case. He had to recuse himself from one of the more important cases before the U.S. Supreme Court this session. And I'm not going to take positions in public that may cause me to have to recuse myself from the important decisions that I'm elected to decide by the voters.
Thank you, Justice Nelson. Ms. Yonkin.
This is a matter that we, all four of the five of us, just discussed last week at the bench bar Clee. And it is something that is important because people want to know, where are you coming from as a human being, in order for them to establish some kind of an identity with you before they can decide whether they're going to vote with you or not. I will not suggest to anyone that I would rule on a particular matter in any particular way. However, unlike any of the other candidates here, I have 3 sessions of voting records in the legislature, and most of the matters, I don't know that I could recite what all 3 of them were, have come before the legislature at various times in those 3 sessions. And as matters of public policy, I could tell someone how I voted on a particular bill, or would have voted on a particular bill, and probably do have a voting record on that. So for me, I feel personally, for me to tell people I have no opinion I'm willing to share with you is somewhat hypocritical, because my voting record is a matter of public record, and people can find that out. So typically, I tell people that came up in the 2001 session, this is how I voted. That doesn't mean that that's how I would rule if the matter came before the court. And I will not tell people that I have a position if the matter should ever come before the court when I'm on the court.
Thank you. Mr. McLean?
White versus Minnesota is a terrible, terrible decision. Terrible. And it's terrible for the following reason. We instruct jurors, please do not make up your mind as to the guilt or innocence of an accused, or as to the outcome of a civil case, until the matter is submitted to you for your deliberation, and until after a full and open discussion with your fellow members of the jury. Then we go and say, but the same law doesn't apply to jurists. We're losing our perspective and our common sense in this whole system. The reason we're doing it is as follows. We have a closed conference room at the Supreme Court, and the reason is the same reason behind having a closed jury room, that you go in there as educated as you can be with your research being done, but with an open mind so you can have a full and honest discussion with fellow jurors. And if you start making statements in public about how you feel about an issue that's coming before the court, you've boxed yourself in, and you're going to be reluctant to change that position. We should conduct ourselves by the same rules we expect lay people to conduct themselves by. And if we start making public statements about where we stand on an issue beforehand, we cannot achieve that. And then we lose our system of justice in the equal and fair standards, as far as I'm concerned. It's a terrible decision.
Thank you. Mr. Morris?
Republican Party Minnesota versus White was a victory for free speech, and I'm a strong advocate of free speech. But we have to recognize we all as citizens have a right to free speech, and with that right to free speech come responsibilities. Some of the responsibilities we have as citizens are not to speak in ways that libel or slander others, or shout fire in a crowded theater. We have the right to say all those things, but there are consequences associated with it, and we have to accept the consequences. One of the consequences of running for judicial office is to accept responsibility that comes with that. The responsibility as a judicial candidate not to pander to particular interest groups trying to win their support and trying to get elected. And I'm not going to do that, and I'm going to be a justice on this court who, if I'm elected, I'm beholden to no interest group. I'm to decide cases fairly and impartially, and I accept the responsibility as a judicial candidate not to pander to particular groups. Now, as to the question as to my views on specific issues, once we start going down that path, we're no longer acting as judges, we're acting as politicians. As I mentioned at the outset, the role of a judge is to resolve real disputes between real parties. So someone asked me, for example, in the question, what's my view on religious symbols in public places? Well, the answer is, as a judge, it depends. If you're talking about dropping a 2-ton monument of the Ten Commandments in the middle of the courthouse, I might have one view, as opposed to showing the copy of the Ten Commandments as part of a display of historical legal documents in a corner of the courthouse. So it all depends on the circumstances of the case. It doesn't benefit anyone as judicial candidate by going out and saying, here's my view on a particular subject when there's no context provided. It's important to have context when acting as judges. If you want to know about people's positions in the background, look at their career, look at the people with whom they've chosen to associate themselves, and that gives you an idea of the kind of judge they're going to be on the court.
Thank you. Mr. Monroe, you have the floor.
For our radio listeners, I'm Greg Monroe from the law school. Justice Nelson mentioned Justice Scalia and recusal, and I think that segues into this question, which I'd like to direct to Justice Nelson. Do you see it as a problem that elected Supreme Court justices in Montana receive endorsements and substantial financial support from major organizations, trade associations, and interests whose cases they will be reviewing? What standard should a justice apply when considering recusal if such a contributor or party is an interested person in the case?
Thank you, Greg. I think that organizations under the law in Montana have the right to endorse candidates. Certainly they have the right to contribute to candidates, and those are legal rights that they can exercise. And I think those are rights which I don't disagree with. All of the candidates are typically endorsed in these races by one organization or another. I have been endorsed by organizations. I'm proud of the fact that they consider my candidacy important and respect my experience, and I have no problem with those endorsements. In terms of money, again, since judicial races in Montana are not publicly financed, it's up to the candidates to get the money necessary to run these races. And I can assure you that running a statewide campaign for any public office in Montana is extremely expensive. You have to solicit lawyers, and if organizations are willing to give you money, that's fine too. I think that given the amounts of money involved, and these contributions are limited to $250 per individual, I don't think that any judge is going to be influenced in any vote that that judge makes by a contribution. I certainly am not. I have had contributions already in my campaign and have had cases before the court, and it has absolutely not affected my vote one way or the other, and that's the way I intend to keep it.
Thank you. Mr. McLean?
We have prohibitions against corporations and certain interests contributing to a judicial race, particularly political party organizations. As to the remainder of the public, whether it is a PAC or an individual, whether it comes from a special interest group or not, the maximum contribution is $250. I agree with what Justice Nelson has said, that $250 is a pretty minimal price to be able to try and have input in a judicial campaign, and that's one of the reasons that the limit is in fact so low, is to keep it where it would not have an undue influence or a dependence on a candidate. In my opinion, there's a message to the public that needs to be delivered by all judicial candidates, and where you are in the pecking order of money statewide, it's very hard to come by enough money to deliver a public message, and you have to go out and raise money where you can raise it. And I see nothing in the state of Montana that allows us to obtain money from any improper source at the present time. Thank you.
Mrs. Yonkin?
I can't disagree with anything that's already been said. It is an expensive place to do a campaign. It's about 700 miles from here to Plentywood. We were just talking about that earlier this evening. It's a long ways from corner to corner here, and there are many expenses that go along with trying to reach all of the people of Montana to try and tell them a little bit about yourself before they go into the voting booth. And I have often said that people are very mistaken if they think that my vote can be bought for $250, because it can't. I don't know that it could be bought for any amount. But you do have to work very hard to raise the money necessary to get the word out about yourself. And I don't apologize for the endorsements that I've received. I've had several. I'm very proud of them. They represent the heart and soul of Montana, and those are the people that we serve. This court serves all of the people of Montana, and all of the people of Montana are entitled to contribute to the candidates of their choice, as are the organizations that they may contribute to in terms of PAC organizations. So I can't disagree with anything that's been said.
Thank you. Mr. Morris?
I defended Montana's campaign contributions in a challenge brought by a group at the Ninth Circuit Court of Appeals. At the time, I thought the contribution limits were a keen idea. As a candidate, on more than one occasion, I've cursed that $250 limit. But I've come to see over time, though, the appropriateness of it. It prevents people from buying elections. It prevents us from going out either as a candidate and buying an election with their own money, or more importantly from other groups going out and buying money. In order to raise sufficient money to get your message out as a judicial candidate in Montana, you have to appeal to a broad cross-section of people at $250. That's the maximum. There aren't a lot of people out in Montana handing out that kind of money. That's a big check for people to write for a political contribution. So I think given our campaign contribution limits and the system we've decided to set up for electing judges, it's perfectly appropriate for any and all groups to participate in the process, and the endorsements of the particular groups help give voters an idea as to the candidate's background point of view, and it's a healthy and robust system. I don't see any need to change it at this point.
Thank you. Justice Warner.
I have to agree with the other candidates, of course. Maybe to make it a little different and to give it a perspective rather than just agreeing, I can tell you what I've done. As Judge McLean said, the judicial races are a little low on the pecking order, and I'm on the bottom of the pecking order in the judicial candidates races, which is a very good trade-off, in my view, for not having an opponent in the election. So that is not a complaint. On the other hand, I have graduated from this place here in 1967, and I've practiced law since then in Montana. And so I know a lot of lawyers. I was president of the bar and a trustee and practiced all over the state, and then a district judge, and I tried cases from Missoula and Ravalli County down to Sydney and Glendive, and from Livingston up in the Havre and Glasgow area. And so I know people. So what I've done is people that I know well, people that I know will not expect any favoritism whatever from me. I have requested that perhaps they would be willing to lend me their good names and to just send a solicitation, which is just to other people. And that way I've managed to raise a few bucks in order to conduct a very expensive campaign. And so under the circumstances, that's just the way I've tried to do it. I have not solicited a single organization, but about, I think, 4 or 5 PACs have just out of the blue sent me some money, and I'm glad to take it. But I couldn't even list them for you right now. And I agree with Justice Nelson and Ms. Yonkin and Mr. Morris. It's just not enough money to buy. I did try, I will honestly say, and I think it's probably noticed that if these solicitation letters, the Montana trial lawyers, and the Montana defense trial lawyers and business lawyers and other lawyers, and I try and get a cross-section that way.
Thank you.
I'm Karen Townsend from the County Attorney's Office here in Missoula. My question is directed to Judge McLean. Montana's right to privacy states, "The right of individual privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest." Do you believe that the enforcement of the criminal law is such a compelling state interest? Why or why not?
I would say that, number one, it depends on whose privacy you're going after. Because Ed McLean is charged with a crime does not mean that you have a right to go after the privacy rights of another individual. To give you an example, the federal law protects mental health records of individuals, even if they are defendants. And that takes a less of a burden for the state to obtain than it does if they're going after the mental health records of a witness. The mental health records of a witness, in my opinion, would be protected from the state irregardless of the reason they were after them. So the compelling state interest is a necessary showing in several cases. It's up to the court to make certain that we do not allow certain evidence to taint the outcome of a case. And when we allow the privacy rights of certain individuals to be breached because the state feels they have a compelling state interest to convict someone, then we're in trouble. So I think the privacy rights do not become secondary because a person is charged with a crime. Certain information concerning that individual becomes subject to disclosure to the state, but that does not make it admissible.
Thank you. Mr. Morris.
We have a right to privacy under Montana's Constitution, but we also have a right to be safe and secure in our streets and our homes. I think when the courts face these kind of conflicts between law enforcement and a right to privacy, we have to inject a notion of common sense. There's a balance here that surely we can't have officers running amok going through people's homes, tearing them apart. But at the same time, we have to allow law enforcement to do a very difficult job, which we ask of them. And the role of the appellate court in that process is to provide as clear rules as possible and step back after you set those very clear rules and allow the police officers to act with some latitude within those very clear rules you've set, not be second-guessing them on every little search warrant application. So we have a very strong right to privacy in Montana. We also have a right to be safe and secure in our homes. It's up to court to strike that right balance, and I think common sense has to be the guide there.
Justice Warner.
The question reminds me, when I was here and was taking criminal law from Professor Elison, who was a young man at that time, he would ask the question, how often do you beat your wife? And that's the same kind of question. Of course, it's a compelling state interest that the right to privacy sometimes be invaded in order to enforce the criminal law. That does not mean that the competing right to privacy interest and the example of medical records has been used is not equally important and perhaps most important. We have a number of cases in our criminal procedure system relating to, and they admittedly most of them have to do with alleged abuses, sexual abuse cases. I think we have a fairly clear law. The mind of man will always think of something different, but now I think we elect people to the trial court bench that we can trust, and that's one of the reasons that they're trusted. And I think that a large part of that balance is properly handled in Montana by what we call the in-camera review, which means the judge gets to look at them and nobody else to see whether they're relevant. As an example, an alleged victim of a sexual assault may have made inconsistent statements or may possibly have lied about further or other sexual assaults, and that would then become relevant. And perhaps that could be introduced. But you don't put that out, my apologies, on NPR and put that into evidence without somebody reviewing it first to see whether or not it is indeed relevant in there. So I believe we do have some pretty adequate protections here for both the safety interest of the public and, of course, the privacy interests of all our citizens in their actual, the way they conduct their lives, the way they have conducted their lives.
Thank you. Mrs. Yonkin.
Well, once again, I can't disagree with anything that's already been said. Certainly, as with many different kinds of constitutional rights, the right to privacy being overcome by a compelling state interest becomes oftentimes a matter of competing interests, and you have to be able to balance those interests to determine whether something is appropriately available to the jury. And if that means having an in-camera review, if that means revealing information that is, you have to reach the relevancy test, of course, first. I mean, there's all kinds of things that have to be looked at before you get to that question of whether there is a compelling state interest. And if you don't cross all of those hurdles and you don't do the balancing that's necessary to start with, then I don't know that you ever get to the question of whether you have a compelling state interest. So you have to be able to balance all of those competing constitutional rights at the same time. The constitutional rights that each of us have to be safe in our homes and in our communities, and the constitutional rights of an accused in a criminal case to their privacy.
Justice Nelson.
I think we need to be clear about what we're talking about here. This privacy and compelling state interest typically and usually only comes up in connection with search and seizure cases. The Montana Supreme Court has historically interpreted the right of privacy in search and seizure cases by using two provisions of the Constitution, Article 2, Section 11, which is the component of, like the Fourth Amendment, and Article 2, Section 10, which is the right of individual privacy, which is the constitutional right unique to Montana's Constitution. We have done that because it's exceedingly clear from the history of the Constitutional Convention debates and proceedings that it was the delegates' intent that Montanans enjoy a heightened right of privacy. We addressed this exact issue, Karen, in State versus Siegel, as I recall. And we applied Article 2, Section 11, Article 2, Section 10 to be one of the first courts in the country to hold that warrantless use of thermal imaging was unlawful, that it did violate the right of individual privacy, the right against unreasonable searches and seizures, and we held that sort of a search to be unconstitutional. Interestingly enough, a couple of years later, the U.S. Supreme Court agreed with us and held to the same thing in the Kylo versus United States case. So I think we have to be clear that we're talking about search and seizure, and in cases where the police and prosecutors and the state does not honor the heightened right of privacy that Montanans have in search and seizure matters, then there is no compelling interest in terms of enforcing the law.
My name is Kristen Juris, and I'm a professor here at the law school. And Ms. Yumkin, this question is addressed to you. I'd like to have you picture yourself for a moment as a sitting justice at the Montana Supreme Court, and a case comes before you and has been briefed by the parties. And in your opinion, the attorneys representing the parties have failed to raise some important arguments that you believe should prevail in the case and be applied in the case. So in that situation, as a justice, would you apply arguments that were not raised by the parties to resolve the case? And I'd also like you to, as a second part of this question, ask, does it make a difference if the parties are pro se and aren't represented by an attorney?
I'll start at the end. Well, and the first answer to the whole thing is it depends. And I think that if there are pro se litigants, that is certainly a time when any court should tend to cut them some slack, so to speak. You know, we've all, as attorneys, have dealt with pro se litigants on the other side, and you do your best to help them along, so to speak, without compromising your own case. And I think that sometimes the court will have to find itself in that position as well, to try and help a pro se litigant to be able to get through our court process. And I think in that sort of a case, if important arguments were left out, then I probably would consider important arguments that the parties have not made. But if you have two very well-qualified attorneys that are representing the litigants in that case, and one of them has failed to make an argument that I believe may have been important to one side or the other, I think I would be disinclined to apply arguments to a case that the attorneys failed to make. Not so with a pro se litigant.
Justice Nelson.
Well, in terms of pro se litigants, of course, the general rule of law is that we do cut pro se litigants some slack. But in doing that, you have to keep in mind that there's the other side of the case, too. There's another party. And it's not the Supreme Court's job to make anybody's case for any particular party. The general rule of law is that we do not consider arguments that have not been preserved for appellate review in the district court. And we adhere to that rule 99% of the time. There are occasions where we go outside the rule. And again, those generally involve some fact-specific case where it's necessary to do that. And I can't think of an instance right off the top of my head, but we, for example, use a rule of law that we will affirm a district court even though the court has used the wrong rationale if it arrives at the correct result. So that's an example. The general rule is, though, unless an issue is preserved for appellate review, we don't rule on that.
Justice Warner.
I would be a little stricter, I think. I think that I would add to the pro se rule that we will cut slack is a good word for it, if you can, in procedural matters. But substantive law, the other side has as much rights as the pro se litigant. It becomes very difficult under our system, but it is our system, and I have found that perhaps it could create chaos. I'm learning this job. that I have now, and I used the word chaos. And I think there is a good reason for the rule that we will not approach or rule on arguments that are not made by the parties. That is because we start to help one side or the other. And they have presented us with questions, and I would have a tendency to answer just those questions, and that's all. And that is very difficult sometimes because I have an opinion on what that might be, and maybe I should go outside of that. But I think that I've taken on a job where I have to have some discipline. And I have to recognize that I don't know everything, and in the opinion of the parties, they've asked the questions that they want me to answer, and that's what I'm going to answer. Because if I don't, I not only help a party, and then I'm taking everything on. But once you start down that road, ladies and gentlemen, where does that road end? Are we going to now start going off on cases and on opinions or on questions that were not presented? And how do you draw the line when you do that and when you don't? Now, in this business, I've learned one thing in the last 15, 16 years. You never say never, all right? So as Justice Nelson says, we have departed from time to time. I'm really hard on that, though. I like to exercise all of the self-discipline that I have, and it would be very seldom that I would violate that rule.
Mr. Morris.
There are circumstances when it's appropriate for a court to raise issues not raised by the parties. First, the most obvious example would be a jurisdictional issue. First issue for a court to address is whether it has jurisdiction over a dispute. If neither party raised it, it's incumbent on the court to raise it for itself and dismiss the case. There may be other circumstances where parties are alleging a breach of contract. No one's raised the issue that there was no contract to begin with. The court can step in there and say there's no contract here, parties walk away. So there are times when it's appropriate for the court to address issues not raised by the parties. Where I feel it's not appropriate for the court to address issue not raised by the parties is with respect to constitutional issues. Even if the court might feel a particular statute or initiative or something is unconstitutional, if these parties haven't raised that challenge, there'll be plenty of time for a later day when parties more able perhaps have raised the challenge and are better able to provide some context and factual development for the court to decide that constitutional question.
Judge McLean.
Well, Justice Nelson states that we don't very often go outside the pleadings to raise issues, but the court does it enough that it is one of the main criticisms of the court going on in the state of Montana today, that if they don't like what's in the pleadings, they reach outside the pleadings to decide a case the way they want, and thus comes the criticism that certain members of the court are result-oriented. They have to stay away from that. As to pro se litigants, the federal courts have a system where you have an attorney to review and assist pro se litigants. The court cannot, absolutely cannot, become an advocate for one side or another. And when you start cutting slack, bending rules for pro se litigants, that's exactly what you're doing. If there's a fault in the system, correct it. Have counsel assist the pro se litigants, but do not say we're going to allow this because we have a pro se litigant. Fix the leak in the tire, but you don't do it by saying we're going to just keep pumping more air in because we have the leak. The problem is you have people going up to court that do not understand the issues, do not understand how to present them, and you don't correct it by having 7 justices up there deciding what rule shall we bend to make certain this person has a fair day in court. It just cannot be done.
Mr. Barterudin, you have the floor.
Mr. Morris, this question is for you. What does judicial activism mean to you? Would you characterize the Montana Supreme Court as an activist court? And what, if any, role does respect for prior Montana Supreme Court decisions have in your concept of judicial activism?
Judicial activism in many ways depends upon whose ox is being gored. If you look at the United States Supreme Court, it's a quite conservative bunch. And yet they have overturned enactments of Congress probably more than any of their predecessor courts in the last 30 or 40 years. A couple of examples, the Religious Freedom Restoration Act. Congress overstepped its bounds in amending the 14th Amendment, in implementing the 14th Amendment. Another example is the American with Disabilities Act. These are all situations where this court has said Congress has gone too far for protecting the rights of the states in our federalist system. So that's judicial activism in one context. The Montana Supreme Court, on the other hand, has generally been accused of judicial activism when it comes to thwarting actions of the legislature that are deemed to go too far in impairing our constitutional rights. So sometimes I think that term is a bit of a misnomer. It depends on your perspective, whether the court is correctly curtailing an overreach by the legislature or if they're thwarting the will of the majority. It's a fine balance to be struck. Now, our court has been criticized for overturning precedent too regularly, and I think there is some justification to that criticism, but it's important to look more carefully at that issue. A number of circumstances where the court has been faced with a situation where you have two parallel lines of authority on a particular doctrine, and they developed over a period of years where it was convenient for an earlier court to decide cases on one track if they wanted a certain outcome, and to use the other track if they wanted a different outcome, and never bothered to reconcile the two because it was convenient to have those. Now, our court has undertaken a number of circumstances where they try to reconcile those two conflicting lines of authority, and that's perfectly appropriate, and it should be done so we can provide some clarity and some predictability, most importantly, for people of Montana. Now, a lot of people in Montana may not like a particular law or the way a statute is interpreted, but as long as the court can be reliable and predictable and provide some ability for them to order their affairs accordingly, then people can live with that. So it's important for a court to respect precedent and overturn it only when absolutely necessary. Now, what point you cross that absolutely necessary line, move into judicial activism, I think is all in the eye of the beholder. But the court has to look at these cases as they come to them and make the decision in a very difficult situation. So I think it's important for a court to respect precedent and step into overturn a legislative enactment only when absolutely necessary, because most of the time you can avoid ruling on the constitutionality of a statute to resolve a dispute between particular parties. There's only very few circumstances when the statute itself is at issue and a challenge usually against the state, and most of the time we're looking at disputes between private parties where a dispute can be resolved without even reaching a constitutional question.
Judge McLean.
To me, judicial activism is when a court goes out and decides to start setting public policy, when it takes upon itself to state something is in the public's interest without having the matter go through the legislative debate and the legislative process. To overturn precedent, in my opinion, is clearly a function that exists within a court. What concerns me about activism versus restraint is, as Brian says, it depends on whose ox is getting gored, is exactly on point. We have to be careful with those two phrases because they tend to be misused. If someone's overturning or someone's doing something you don't like, to call it activism is not an accurate description. To me, activism is when a court has an agenda, and if it involves public policy without public debate, then it becomes activism. For a court to overturn precedent that it deems to be bad law or to correct two divisive points coming together is well within the realm of a court's duties and does not constitute activism. So I think we have to be careful with the way we throw language and terms around when we're talking about activism versus restraint.
Justice Warner.
A lot of good opinions, but when you get there, many times I have found public policy is thrust upon you because it's necessary to set some kind of a policy when you have to make the decision. That's one thing that the judge doesn't have or the appellate court doesn't have. We don't get to say maybe. It's up or down, it's yes or no. And under these circumstances, I would say that judicial activism is probably necessary in some instances because you have to go somewhere. On the other hand, I would tend to say that no. You should try and stick with the policy that's been set. Do your very best to figure out what the legislature or the laws in place have said and what the Constitution is. We often refer in our relatively new Constitution to the Constitutional Convention debates. So I do not believe that judicial activism is a good thing. On the other hand, decisions are required, and I would have a tendency to let the policy be set by others, and that's how I would kind of defend it, or define it, excuse me, is saying that if you reach out and set a policy where you don't have to, you're being an activist court. Precedence has been brought up. Many times, both sides of a question will do a lot of research and give you very good reasons why precedent should be upheld. Stare decisis is very important in our system, and they will also present very good arguments why they're no longer there. It was back in the 15th century when, in Calvin's case, it said that the law is an ever-growing, evolving thing, and human laws are born, live, and die, and stare decisis cannot rule our lives. I've said, and I will keep on with this, that precedent is very important. The rule of stare decisis is important because we know how to conduct our personal affairs if we know what the rules are in the game, and businesses know how to assess risk, and we know how to conduct our businesses in all of our affairs. But when it becomes no longer applicable or doesn't work, we just won't. We have to discard it, and that's.
Justice Nelson.
Well, labels, I think, generally and typically are a mile wide and an inch deep, and judicial activism is such a label. My definition of judicial activism is a court which ignores the law, ignores the plain language of the Constitution, ignores the plain language of the law, and writes to some preconceived, preordained result, notwithstanding what the Constitution and the law says. We've talked about the court overturning precedent. Sure we do. The court over the last 10 years has been very diligent in trying to reconcile conflicting lines of authority, conflicting standards of review. I've written a number of opinions that have done that. And the object of the exercise is to try to clarify the law, not to continue cases where there's different cases holding to different results and so forth, different burdens of proof. We don't overrule cases lightly, but then again we don't do it on the basis of surveys and law review articles and that sort of thing either. It's always interesting to me, and I know there's a current law review article out criticizing the court for overturning precedent. A couple of years ago, the author of that article was before the court in a case called State versus Alana Wells, and if the argument made at that time were accepted, we would have had to overrule 3 cases. So again, I agree with Brian. I think it's whose ox is getting gored at the time, and I think that the best thing you can do is look at each individual case and to judge on the merits of that case whether cases which have been overruled should have been overruled or not.
Mrs. Yonkin.
Well, it's interesting that the law review article was brought up because it just came out yesterday, I believe, and I happen to have a copy of it here. And I can't wait to read it from beginning to end, but it was handed to me this afternoon. And I think that the research done in that law review article, the empirical evidence there will indicate that our Supreme Court has become activist. When you compare the caseload of this court, the number of cases that have been overturned per thousand as compared to other states without an intermediate appellate court, all of those things tend to indicate that there is something askew with our Montana Supreme Court when you compare us to other similar courts in states without intermediate appellate courts, in states of similar sizes, in states with similar caseloads. I think that the activism label, I mean, people don't like labels, but you have to look at what the evidence indicates, and whether our court has become activist or not, I think, is borne out by the facts and the research in this particular law review article. And I define activism the same way others have. When the court goes beyond the issues that they have been asked to rule upon, when the court second guesses what the law was intended to be by the people, when the court rules on matters they haven't been asked to rule upon, when they've based their opinion on arguments that nobody made, I think all of those things go into the definition of what is activism versus what is restraint. And it is important for the people of Montana to have a court that respects the law to provide the stability and predictability that they deserve in order to know how to plan their lives, in order for attorneys to know how to advise their clients, and in order for Montana to continue to grow and prosper. And when those are undefined issues of law out there because we don't have the stability and predictability, that's not good for Montana or the people of Montana.
Greg Monroe again, and I think that comment by Ms. Yonkin segues nicely into the next question we have. We'll address this to Justice Warner. From your observation, identify a common criticism of the Montana Supreme Court that you think may be fair and one that is unfair.
Two. Criticism. Well, whenever I was reversed, it was unfair. And when I was affirmed, it was fair. And my record has been pretty good since I got there. Now, I think that a criticism, I don't know that it was phrased in terms of activism, but one of the criticisms that I made, and one of the reasons that I wanted to be appointed to the Supreme Court when I had no ambition to be there, is that I felt that too often, or more often than should be, the rules were changed on me and that I could not do a good job because I didn't know exactly how things were going to go, and I could not find this predictability that I preach in the court. And that is a criticism that I felt was justified. And therefore, now I've just said something. So I guess if you like it or don't like it, but that's the way it is. That's the way I felt. One of the best things about this court, and one of it is the most hardworking bunch, and the most 7 people with the highest integrity and the highest level of intelligence that really try within their own philosophies to do the best for the state of Montana that I have seen. I guess I should have said 6 others and myself. I'd like to include myself in there because I'm going to strive to do that. So that, I think, is something that you can all truly be proud of as a selection that you've made on your court, although I do disagree with them from time to time, and I have been known to write a dissent or two, especially this week. And so under those circumstances, I've tried to answer your question. It's difficult to do because each case is specific, Professor, and it's difficult to pick one out. Okay.
Justice Nelson.
Well, I think the most unfair criticism of the court is the one that's already been mentioned, that the court is activist. I absolutely disagree with that. This court, over the past decade, has really tried, and I think succeeded, in giving voice to the 1972 Constitution and to the unique rights that individuals have under that Constitution, and that is why we're elected. That's our job. We take an oath to support, protect, and defend the Constitution, and we have done that. And I can appreciate there are those whose oxes are gored by that, who think it's activist, but indeed just the opposite is true. It would be activist of us not to interpret the Constitution the way it was written and the way the delegates intended it. I agree with Justice Warner. I think our court is probably one of the most hardworking, intelligent group of people that I've ever been privileged to associate with. I'm very proud to have served on the Montana Supreme Court, and I think that we've done good work for the people of the state of Montana, and we'll continue to be able to serve the people of this state and to defend the unique Constitution that we all enjoy in the future as well.
Judge McLean.
Well, our court is a hard-working court, but that doesn't make them the only intelligent people on the block. And our court has to learn what its respective position is in our system. And it cannot be going down and deciding that there's an abuse of discretion on the part of the trier of fact every time they do not like an outcome. They have to be on guard that that's an open criticism. It's being talked about across the bar of the state of Montana. not just in prosecutor's office, but in civil defense offices and in civil plaintiff's offices, that they're being criticized for a lack of consistency. And I think the lack of consistency is because a lot of people out there feel that the court has a result that it wants to achieve and will take and apply the law that it feels will achieve that result. And if that comes down to holding that a district court or some trier of fact abused its discretion, the court has a reputation for doing that. And by saying that, I do not mean to impugn the integrity of the court at all. They are a hard-working court, and each and every one of them is a very honest individual. However, that does not prevent one from letting one's philosophy dictate the course it's going to come. And it's easy to say, well, we'll overturn this case because it's no longer the law in Montana. And we reached down and grabbed the 1972 Constitution to change something that no one's raised in the pleadings. That's improper and it should not be done, and it is a valid criticism of the court. Hardworking, diligent, and very honest people make mistakes, but the court has to be aware that there are those criticisms, and they are in fact valid criticism.
Mrs. Yonkin.
I do believe that there is some level of fairness in the criticism by many that we do have an activist court, and I think that the evidence bears that out. And what we were just talking about with the seeming lack of respect for stare decisis and the lack of stability and the lack of predictability. And when you talk to people across the state, attorneys across the state trying to advise their clients in certain areas of law, they don't know what the law is because it seems to be changing fairly frequently. And I think that there must be something to that. It's not just me that's having a hard time knowing how to advise my clients in certain areas. There's other attorneys as well. The one criticism I think is unfair is probably something you hear more from the general public, and that is that there are those that believe that the 7 judges in their black robes sit up there and pontificate, and they seem to just come up with something and rule on it. And I don't think that that's fair. I think that our court has a lot of very, very difficult decisions to make, and I don't believe that there's a single justice on the court that takes any of their decisions lightly. They put in a lot of time in researching them, their clerks do, and they put in a lot of time in reading a lot of briefs, and it is hard work. And I do think that none of the decisions that they make are taken lightly, and they do spend the time necessary to make the opinion that they believe is appropriate. I just happen to believe that some of those opinions are wrong.
Mr. Morris.
A fair criticism of the court would be a lack of common sense in some of the criminal procedure cases. An example would be the Hardaway case from Billings, where a woman called the police reporting an intruder had broken a window in her home. The police arrived at the scene and found blood on the floor inside the house, and shortly thereafter captured a man hiding in the bushes outside the house with blood on his hands. The police, wanting to tie up the case, took a swab of the open wound of the hand to test the blood for the blood found on the floor. The police weren't trying to violate anyone's rights, weren't trying to sneak and confession out of the defendant, simply taking a swab of an open wound. There was no invasive procedure involved. And that was held to be a search for which a warrant had been required. I don't understand how that's different than taking a fingerprint of a person, how that's taking a test for powder residue after firing a gun. So I think lack of common sense in some cases. We elevate our right of privacy, which is very important, but we also have a right to be safe and secure in our homes. So I think you have to use an element of common sense to make that balancing. An unfair criticism of the court, I believe, would be some of the court's decisions relating to personal privacy and autonomy. If you look at our federal court, the United States Supreme Court, they've taken penumbras and emanations of penumbras and used that to string together a series of cases protecting our rights to use contraception, abortion, to outlaw sodomy. All those kind of cases in the federal system, when there's no explicit right of privacy in our federal constitution. Montana, by contrast, has a very explicit right of privacy. So you take those federal cases and you tack on Montana's explicit right of privacy, I don't think it's surprising you see in the outcomes we've had in Montana with respect to decisions related to personal privacy and autonomy.
This is Karen Townsend again, and this question is directed to Justice Nelson. In the State versus Gray case, the court declined to impose a procedural requirement that police must tape record or create an audio-visual record of Miranda warnings and the detainee's waiver. Although they stated it was the better practice, it should be left to the legislature or individual agencies to impose that requirement. That decision was made in 1995, and so far the legislature has not acted, and most agencies have not. Do you think it's time for the court to impose that requirement now?
Well, Karen, to answer your question directly, no, I don't. For one thing, of course, if we do that, that is exactly what we're being accused of, as being activist. We're legislating from the bench. We probably will not do that. We suggested in that opinion, and we suggested in the State versus Worrell opinion, which you're probably familiar with as well, that when at the station house, the police do not use the common ordinary tools at their disposal, pen and paper, visual taping, audio taping, taking notes, taking a witness statement. When they don't do that, that at least in the judicial analysis of evidence, that the court may view that evidence as not being particularly credible. And that, to me, makes perfect sense. But in saying that, it's ultimately up to the individual police department or sheriff's office what they do with that. I would think that if common sense were to prevail, that you would do whatever is necessary to document your case in the best way possible to assure a conviction. It always struck me when I was a prosecutor that there's battles you don't need to fight. And one of them is poor case preparation. One of them is the police officer who won't take a witness statement, who won't take notes. And we're talking about station house interviews, not what happens out in the field. Those are governed by different rules. But ultimately, that's up to the individual police officers. I don't think it's up to the Montana Supreme Court or any other court to dictate to an executive agency, such as a sheriff's office or a police department, how that agency should run its particular operations. I think the Gray case and the Worrell case stand for what they say, and I think, at least in my view, that's probably as far as we should go.
Ms. Yonkin?
If it wasn't appropriate in 1995 for the Supreme Court to rule on it, it wouldn't be appropriate today, even with the passage of time. If that is a matter that the court then said should be addressed by the court, or by the legislature, or by the enforcement agencies, then that's still the appropriate place for that matter to be addressed. And if the legislature has failed to pass necessary legislation for law enforcement and prosecutors to have the guidance that they need, then perhaps that should be brought to their attention by the Justice Department. But it sounds to me more like it's a matter that could be dealt with through internal operating procedures within the law enforcement agencies to utilize the all materials available to them to build the record necessary for the prosecutors to get a conviction that will stick.
Judge McLean?
Well, one thing that troubles me is that we do not have a law, a legislative enactment, that says that statements and the advice rights have to be recorded. And the legislature has refused to do that. Justice Nelson says that we should not do that, but at the same time, the court authors an opinion that says if you don't do with it, if you do not do that, it will be viewed with distrust, any oral statements by the officer. And I have trouble with that. You're saying that the court will not address it, but at the same time you are addressing it, saying that if an officer doesn't have it in writing, it's going to be viewed with distrust. Well, that is addressing it. And why not be proactive and just say, if you're going to have statements admitted by law enforcement, that they should be in writing. I think that it's proper for that to be addressed in a legislative session, and the court should have a rule that says that a witness's credibility is to be judged by the jury. you don't start instructing the jury to mistrust your police officers.
Mr. Morris.
One of the great successes in our country has been our criminal trial by jury right. And one of the ways that trial is put to the test is by a full and unfettered cross-examination of witnesses, including witnesses who are police officers. Defense attorneys have that right, and they have the ability to undertake that kind of cross-examination to point out to the jury, who are people just like you and me, why someone should not be believed. And it's up to the jury at that point to believe whether that statement is trustworthy. The legislature has not taken up the court's suggestion they should act, and that's the legislature's prerogative. It's not for the court to step forward at this point. Now, there's been no evidence in Montana that we have a real problem with abuses like this in the last 10 years since 1995. By contrast, in the state of Illinois, they've had a real problem with their capital justice system, capital crimes, where there have been a number of alleged false incriminations by defendants, and there was a big uproar. They ended up suspending their death penalty. And the legislative committee put together, one of the suggestions was to tape all cross-examinations. That's perfectly appropriate for a suggestion like that to emanate from the legislative committee and be enacted by the legislature. In light of the fact they felt they had a problem in the state of Illinois, it's up to the people of Illinois to do that. People of Montana can do the same thing if they want through their legislature.
Justice Warner.
I want to posit a question to the group here and to the panel of moderators, considering the answers that have been given to the question previously, and to compare that with the decision of Minnesota Republicans versus White and the new canons that are coming down from the American Bar Association relating to judicial impartiality, as to whether these comments would disqualify any of the members of the panel from sitting on a case in which that question was brought forward. Now, I'm not going to posit an answer for you to that question, but I think some of the answers to these questions should certainly bring that to mind, as you asked me at the beginning of the case, of the forum. I have a different view. I think that the comment about mistrust under the circumstances, which came in a suppression hearing in which the decision to trust or not to trust was made by a fact finder that happened to be a district judge. And the review of that decision should have been made by the Supreme Court as to whether or not there was an abuse of discretion or whether there was a fact issue that was inappropriately resolved by the district judge when he made that decision. I do not think that. I think exactly that an appellate court there made a comment on the law. But that comment on the law, in my view, and in the way I applied it, was something that I didn't think was entirely appropriate, because I knew, and I would posit, that all 42 district judges in the state of Montana know that when a cop gets on the stand and says that I gave somebody Miranda warnings or I didn't, but they're not on the tape, that the district judge who is charged with making that decision has to say, I believe you, officer, or I do not believe you, you did not give those rights. And it's just a comment on the law to say it's viewed with distrust or not. But where they were really asking whether it was an abuse of discretion or whether there was any evidence to support the district judge. Therefore, that would be my view on that particular item, and I think that it's just the same as that there's an instruction at the Law Enforcement Academy to police officers that after you make your initial notes, that you go out there, you rip them up so that the defense attorney can't get them. I knew when I was sitting there reviewing the police officer's testimony, every time that happened, I thought, what are you hiding? But then if you've got good counsel for the defense, they'll bring that out in spades. And of course, good prosecutors, as you well know, will cover that up on their direct examination as to what happened. And so I just think that was a comment on the law, and I would not do that in an appellate court.
Ms. Jurist, would you like to propose the final question from the moderators?
I'd like to ask you if we have the time to do that, or should we go to the questions from the audience?
If the candidates will please keep their responses brief, we can have one final question.
My question is directed to Judge McClain. As a result of the Montana Supreme Court's growing caseload, fewer and fewer decisions are being made based on oral arguments. Instead, the court is relying on the briefs and the written record? And as a justice, what criteria would you use in deciding which cases should have oral argument? And as a part of this question, is it time to once again revisit the need for an intermediate appellate court?
Well, addressing your question in about 3 parts. First of all, I think that we need more oral arguments before the court. And I think we do that because the public becomes far more educated to our judicial system when they can observe it in operations. One of the best public relations move that our present court has done is going around to various community and hearing oral arguments. And there are enough cases of great import that oral argument could be heard more often. I am opposed to an intermediate appellate court, number 2. And the reason for that, number 3, is I think that the court can clear up a lot of its cases with some per curiam opinions, instead of saying this case shall not be cited as precedent and then going on with a 15-page opinion. The court could simply say, for reasons stated in the findings of fact, conclusions of law, the district court is affirmed, or the decision, the verdict of the jury is affirmed, or some other reason. And they could do that in a lot of per curiam opinions concerning domestic relations. 8 years ago, when Justice Regnier was running for the court, he stated that it was legal malpractice not to appeal every case because there's no consistency up there. And that is held true today. It's because of our lack of consistency that everybody is appealing so many cases, and I think that can be streamlined a great deal, particularly in domestic relations matters.
Mr. Morris.
I think it's important for the court to increase the number of cases that they hear an oral argument. One way they can do this is to shorten the time period. Instead of having 40 minutes per side, which is about the longest oral arguments in the country, shorten them down to about 15 minutes per side, give some direction to the parties as to the particular issues that are relevant in that case. Too often a party will raise 6 issues on appeal and come to oral argument and want to talk about all 6 of them. The court says you've got 15 minutes per side, address these 2 issues and these 2 issues only. You can expedite the process. It allows greater interaction between the court and the members of the bar, and more importantly, it allows the public to see what's going on and understand the decision-making process the court is taking, what arguments were actually put to the court, and it's a healthy thing for all parties involved. If I'm on the court, I'm going to push to see that that happens. With respect to the second part of the question about the Intermediate Court of Appeals, I think its time may come at some point. I don't think we're there yet for a number of reasons. First, we have not yet undertaken every effort to streamline the decision-making process. As Judge McClain mentioned, we could go use more memorandum opinions where we're shortening the time period needed by judges to write opinions in certain cases. The court's caseload is growing every year, and if you divide the number of cases by 7, you get an idea of how many opinions judges have to write. Some percentage of that can be cut down through these memorandum opinions.
Thank you, Mr. Morris. In the interest of time, we have to move on. Justice Nelson.
I think that the more oral arguments we can have, the better. But the criteria I would use are the same criteria we use now. Constitutional issues, issues of first impression, issues involving divergent lines of case authority and so forth. Those are the types of cases that should be orally argued. The great mass of cases that we deal with don't need oral argument. In terms of shorter opinions, non-side opinions, memorandum opinions, we are doing that now. And of course, when you get out around the state, one of the biggest criticisms I hear from attorneys is too many non-sites, too many memo opinions. You know, I put all this work into the brief. My client wants to know why I won or lost, and you guys turn out a one-page opinion that doesn't tell us anything. So I think there's some balancing there, and I think the litigants in Montana who have a right to justice under Article 2, Section 16 of the Constitution deserve to know why they won or lost in the appellate court.
Mrs. Youngkin.
I'll address the Intermediate Appellate Court first. I agree with Brian. I don't think that we are there yet. I think if the court had more predictability and stability, that the caseload would come down somewhat. I don't know that it would come down drastically. Who knows how much it would come down. But I do believe that if practicing attorneys across the state knew what the law was and what to expect out of an appeal, that there would be less likelihood that so many cases would be appealed. I also don't know that the state state is ready for that in terms of the cost. The cost is very significant. And it's not just a cost to the taxpayers of Montana, it's a cost to the litigants. And every time you have to go before a court, it doubles your cost again. And I think that raises additional issues with access to justice that need to be very carefully considered. Beyond that, I forget what your first question was. Oh, the oral arguments. I'm sorry. I would agree that the criteria that is currently being used is appropriate. The constitutional issues, cases of first impression and statewide importance. And I would also agree that having the court leave Helena and get out into our communities was one of the best things that they ever did. Coming to the various college campuses around the state has exposed hundreds and thousands of Montanans to something that they would not otherwise have the opportunity to see. And the more exposure the public has to just watching, the more they will feel ownership to that, the more interested they will be in who their judges are, why should I care? And I think that it's just an educational process that's so critically important and would encourage
Thank you, Mrs.
the court
Yonkin.
to
In the
continue
interest
doing
of
that.
time, we have to move on. Justice Warner.
We are orally arguing all of the cases that we can. I have posited to my colleagues that we should shorten oral argument to 15 minutes per side, and that includes the rebuttal. What the consideration of that will be remains to be seen. The justices would all like to orally argue more cases, but the caseload is just overwhelming. I disagree with Judge McLean. I was going to say vehemently, but the deal is that the court has become one vote more consistent since last May. What was the rest of this now? Where are we going here? The appellate court. You got to walk a mile in their moccasins, folks, before you know it. That's the only solution. I'm sorry. Whether it'll come, no, it's not going to come. The legislature is not convinced. I have been there now, and I know that this thing is going to ratchet down throughout my legal career. The caseload's going to increase. I can't go any faster. We're using memo opinions now, and if you will bother to look and do one of these law review articles, you will find that the non-cite opinions have a purpose, and they're getting much, much, much shorter. There are no more 15-page non-cite opinions, all right? I don't think. Never say never in this operation. I would posit that when the legislature can get around to it, we should have a 5-member Supreme Court, a 7-member intermediate appellate court, and it should not be elected by districts. It's a huge expense, and it's not going to come during my judicial career very likely, but I'm here to tell you now, and as I'm a plain-spoken guy, that's the only solution. You're either going to do it, or you're going to have delays, or you're going to suffer a lapse in quality. That's the story.
Candidates seeking seats on the Montana Supreme Court, answering questions from a panel of moderators here at the University of Montana School of Law, where a debate among those candidates is taking place. We are broadcasting that debate live to you this evening. The audience here at the Castle Center has been asked to jot down questions for the candidates. We have actually a member of the Federal Society and some other students have sorted through those questions, and we'll present them to the candidates now.
This is a question that is addressed to all the candidates. In opinion polls, Montanans have consistently shown more interest in strengthening our state's economy than in any other issue. For the incumbents, what steps have you taken to ensure that our state's legal rules promote a strong economy? And for the challengers, what steps would you take to ensure our state's legal duties to promote a strong economy? Ms. Nelson.
Well, I don't know that it's an appropriate function of a court to promote anything. We're not in the business of promoting the economy or promoting business. Our job is to resolve disputes, decide cases, and interpret the Constitution. Contrary to what some organizations may think, when we get a case before us, we don't sit and think, well, is this pro-business or anti-business? Or should I decide it this way to promote this or that way to discourage that? That's not the way we decide cases. And if we have a court that's going to do that, then you've got a judicially activist court of the worst extreme. The court's job is to support, protect, and defend the Constitution, to to interpret the law, and to resolve disputes, period.
Mr. Morris.
One thing the court can do to not necessarily promote business per se, but promote predictability. And I mentioned earlier about you may not like the way the law is interpreted, but you can be consistent about it. An example would be how an employer goes about firing or discharging an employee. The court has to be very clear about what those rules are, and the employer should then be able to rely upon the direction given by the court. If I follow steps A, B, C, and D in firing an employee, I will not be successfully sued in court. And that's a way we can promote some predictability for businesses. And the other thing the court can do with respect to promoting business is looking at the Constitution, interpreting it incrementally, the same way we develop tort law as a common law on a case-by-case basis. Only interpret the Constitution when absolutely necessary. Don't make statements about what direction the society ought to move, but simply resolve the dispute between the parties and interpret a provision of the Constitution only to the extent necessary to resolve that dispute.
Judge McLean.
The criticism of our court is that it is not consistent, and that is what spreads the paranoia throughout the business community. Whether it is a just criticism or not does not eliminate the fact that that criticism is out there. Our court has to be very cognizant of the fact that it has to have a consistent rule that people and parties will know the outcome if they do follow certain procedures, as Brian has just stated. And until we have that consistency, we're going to have a state of uncertainty, and when we have a state of uncertainty, we have a state of mistrust among our businesses towards the doing business in Montana.
Justice Warner.
They stole my speech. When I applied for this job, it was my first shot through the Judicial Nomination Commission. I'd always run for election before for my seat on the bench. One of the business lawyers that was interested in the job, and he just kind of appeared out of the blue one day, and this was a business lawyer. He hadn't appeared in the Montana Supreme Court, maybe never, but at least not for the 15, 20 years that I'd known. And he showed me an actual letter that they had written several months before to a business inquiring to come to Montana as to whether or not and they asked some lawyers and lawyers of repute as to what the business climate was, and the response that they'd actually sent back to a client was that we cannot predict the business climate here because we don't know what the precedential value is going to be and how the Montana Supreme Court's going to rule on cases that might come before it. Even if you're not a party, you might not know. And so it's the mantra that we all understand. And I think it's very important, and that's what I've been trying to do, and I hope I've had an effect.
Well, you should be last and have everyone else give your speech too. And I couldn't agree more. I think it is inappropriate for a court to promote anything. However, what the court should be very cognizant of is the stability of the law in Montana. And when the court does not offer that, then people don't know how to plan their lives. Whether you're a Main Street business, a rancher in eastern Montana, a lakeshore property owner on Flathead Lake, it doesn't matter where you are, you've got to have some level of certainty in order to know how to plan your life. And perception is everything when it comes to public service. And the perception is, whether it's real or not, the perception is that Montana is not a good place to do business because of our court system. And I didn't come up with that perception. There is that out there, and that's what people rely upon when they're deciding, am I going to grow my business, am I going to bring my business to Montana? And I think just offering the stability and predictability in our judicial system will go a very, very long way to turning that perception around.
Mrs. Yonkin, this question is addressed to you. What are your personal beliefs on tort reform?
One of those GOP versus Minnesota questions. There again, as a legislator, we've had various measures involving tort reform come before the legislature, and I think that most of those matters are matters of public policy that are correctly left before the legislature, and some of them work and some of them don't. You know, there's the issue of loser pays the attorney fees, and there's the upside and the downside of that. That's not anything I ever voted on in the legislature because it never made it to the full floor of the House or a committee that I was on. But those are matters of public policy that I think are best left to the legislature.
Justice Warner?
Agreed, of course, but that's the way the system is set up. My personal views on tort reform are that the legislature has a very strong presumption that its enactments are correct, and that must be followed. On the other hand, as you will recall, well, you won't recall because most of you are too young here, when I was coming through, we hadn't adopted the rule of strict liability in tort. It was actually, it was just coming, and as I understand it, I've just gotten the hook. I don't. In any event, so the tort reform, there has to be some legal interpretation there, and I would not deny that that's there, and that's how the growth of the common law has occurred over all of these years. I would approach it very deliberately and with a very cognizant and researched idea of the needs of the society, and I am afraid that I would have to own up, at least if my children are correct, that I am a conservative individual.
Judge McLean?
Well, where we're coming down on the question of tort reform is when you look at tort reform versus constitutional provision of an individual having a right to full redress under the law. And the big rub comes when insurance companies charge a person multiple times for underinsured coverage or uninsured motorist coverage. And then when the person does in fact get in an accident and there is an underinsured or an uninsured problem, and the person turns to his own or her own policy and what we call a stacking provision, the insurance companies say that's against public policy, but yet they don't want to stop charging the multiple premiums. And so you've got a rub, a legitimate rub that comes in. If you want to have public policy set by the legislature in the way of tort reform and addressing certain problems, you cannot allow an insurance company to be collecting multiple premiums and then say that there's no liability when the insurance company is in fact charging multiple premiums. And that's where people seem to come from when they talk about tort reform. And when we talk about tort reform, we have to make certain we put everything on the table in front of the public to know exactly what the cost of that reform is.
Mr. Morris?
Like many other things that judges do, it's a matter of balancing of interest. We have tort reform in various contexts in Montana. We have a workers' compensation system that is a form of tort reform. Workers give up a right to unlimited possible recoveries in exchange for reliable recovery. And the employers give up the ability to fight the liability in exchange for a reasonable amount of payment on their part. So it's a question of how do we balance the right under Article 2, Section 16, I think it is, for full legal redress with the litigants, with the amount set by the legislature as being the cap on any recovery. And again, it's something that depends on the circumstance. You certainly can't say we're going to limit recovery to $1,000 or some arbitrary number. It has to be tied to something in reality, something that's happening out there. If there's a showing that people's economic recovery should be 3 times their annual income, or then that's sufficient, then it's up. The legislature has to make those kind of findings if they're going to ratchet down people's recoveries. So the court has to balance the different interests, look at the facts of the case presented, and this is a question that's difficult to respond to out of context, because it has to have a real set of circumstances as to what the amount set by the legislature is, what are the facts showing as to the type of claims, as Judge McLean mentioned, if it's a matter of insurance companies taking advantage of multiple premiums for underinsured, uninsured motorist policies and then not wanting to pay on those, what are the facts of those cases? So it's up to the court to balance the competing interests and come up with responses that are reasonable and tied to actual circumstances of the cases.
Justice Nelson?
Well, again, my personal views on tort reform are irrelevant. The legislature is the appropriate body, obviously, to pass laws, and if some of those laws include tort reform, that's the legislature's business prerogative to do that. It's the court's prerogative and business to resolve disputes as to whether or not those sorts of laws are constitutional if and when they're brought before the court in an appropriate case, in an appropriate fact situation, with appropriate legal arguments. Then it's the court's business to determine whether or not those laws pass constitutional muster under Montana's Constitution. Again, the personal views of any judge, I think, on that particular issue are irrelevant, and it's simply, as Mr. Morris indicated, when those challenges are made, we will do, and I will do, the same that we do in any case. We look at the legal arguments, we read the briefs, we do the research, we look at the facts, and make our decision accordingly.
I think we have time for one final question. This is directed to all of the judicial candidates. What is your position on the proposed amendment to the Montana Constitution defining marriage as between a man and a woman exclusively? Justice Warner?
I don't have any position on that. That's an amendment to the Montana Constitution. You amend the Constitution, that's the way it's going. And since this is the last time that I'm going to have to address you, thank you very much for listening to us, and to me in particular. Yeah, right. And don't listen to any of these other guys. On the other hand, it's been very gratifying to be here, and I appreciate it. And I hope I wasn't too brusque, but if they amend the Constitution, then it's in the Constitution. If they don't, then we'll decide it when it gets there.
Justice Nelson.
Well, I too would like to thank you all for your interest in this very important topic and this very important election. One of the constitutional rights that Montanans have retained in their Constitution is the right to amend their Constitution. All power of government in Montana derives from the people, and they're in charge of what they want to put in their Constitution. Other than that, I don't have a position on it. I know that there's a move to draft an initiative to do that, and whether that succeeds or fails will be up to the people of Montana.
Ms. Yonkin.
I would agree. If the people amend their Constitution in such a fashion, then that becomes part of the Constitution. And as long as the appropriate procedures to do so have been fully followed in a constitutional manner, as we all know, there are a lot of hoops you have to jump through in order to get those on the ballot. And if the proponents of that are able to do so in the appropriate manner and it is properly drafted, then the people are free to amend their Constitution in any manner they wish by amending or repealing. You can amend by repealing as well. So, and I too would like to thank all of you for your attendance, and thank you so much for the opportunity.
Mr. Morris.
I guess I was to echo comments by my colleagues up here. It's not for the court to decide whether that's a necessary public policy. That's for the people through this initiative process. One of my roles as solicitor for the state is to defend the constitutionality of statutes and initiatives, and in that role I don't necessarily decide, well, would I vote for something in the legislatures that needed public policy. Instead, my role is to decide whether it's within the parameters of the Constitution for the legislature or the people to do so, and the people can do as they please with up to certain limits, as long as they're not amending the Constitution in a way that conflicts with other provisions of the Constitution, or as long as they're not amending the Constitution in a way that violates the procedures, as Ms. Yonkin mentioned, for example, the CI-75 case or the term limits initiative, where there were challenges to the ways by which that Constitution was amended. As to the substance, again, that's whether that's needed public policy, that's up for the people to decide.
Judge McLean.
Thank you. And folks, thank you very much for having us here. If the Constitution is amended, you then have a Constitution with a new provision, and it does not become a question whether you like or you dislike it. That's the Constitution, and it's your job as a justice to uphold the Constitution, and it becomes that simple. Thank you very much for having us.
At this point, I would like to thank everyone for coming and to re-thank all the organizations, groups, and people that helped put this on: the Federalist Society, the American Constitutional Society, College Republicans, Environmental Law Group, Montana Trial Lawyers Association, the New Lawyers section of the Montana State Bar, the Women's Law Caucus, our wonderful, wonderful moderators who did a wonderful job tonight, Shandor Badarudin, Greg Monroe, Kristen Juris, Karen Townsend, and of course Stacy Gordon and Robert Nadelson, Dean Fritz Schneider and Dean Tona, and all the library and law school staff and faculty who have helped bring this all together, and especially to our judicial candidates tonight who traveled a long ways to get here to be able to talk with us tonight. Thank you all so very much.
You've been listening to a live broadcast of a debate among the 5 candidates seeking seats on the Montana Supreme Court. We've come to you live from the Castle Center at the University of Montana School of Law, where Laura Walker has been our MC. Thanks to her and Christian Herr for their help in setting up this broadcast, and to Richard Kuschel of the Recording Center for, as always, providing excellent, reliable sound. Thanks also to Randy Rocks, Ken Siebert, and Chad Reinhardt back in the studios at Yellowstone Public Radio. Signing off from the Castle Center in the Law School at the University of Montana, I'm Lenny Holloman. Thank you for listening.